Did you ever wonder why it's so hard to retain a civil litigation attorney? You might think that, look, I'm paying your hourly rate, you have billable hours, you're making money on this case. Well, it's not always about the money with attorneys. Being a practicing licensed attorney means you can work on any number of things. Litigating cases in court is probably the least desirable of all of them. Look at this ad we saw on Instagram recently where this company, it's called Case Fuel, not familiar with them at all, hadn't had any familiarization with this company. They're advertising how to escape the courtroom, never work a heartbreaking case again. This is a company that is advertising to attorneys in a way that is trying to get attorneys to buy their software, program, whatever it is, to get them out of the courtroom. So obviously that's a pain point. Obviously there's a large number of attorneys that don't want to be in the courtroom. That's not a bad thing. It doesn't make attorneys bad people. If you have a choice in your job of what type of work to engage with, what is going to be your first choice? You're going to be doing the thing that has the most benefit to clients, has the least impact on you as an employee or business owner, and has the most revenue. Litigating in court is the worst of all evils. Here's why. We see this all the time. If you're an attorney and you can work on things like probate cases or corporate formation or even settlement negotiation, those tasks and those efforts can all be done from your office with all the resources right around you. You can reach out to your paralegal. You have access to all of your computers. You have access to your support staff. If you go to court, not only are you on your own without your support staff, but now you're in the heat of the battle where the outcome is not guaranteed. You're right in the middle of a very serious conflict between two parties. Because look, once a case goes inside the courtroom in full litigation, that's when all other types of settlement or mitigation have failed. There was no mediation. There was no settlement. There was no negotiation. The parties couldn't come to an agreement. In fact, it was so toxic that they are willing to pay tens of thousands of dollars more to go to court than to avoid court. In many cases, the reason for that is out of spite, where they just believe that even though it's going to cost them more money, they want to get their pound of flesh. Look, attorneys are like human beings. They don't want to deal with that kind of toxic worst of humanity than anybody else. When you go to court, you're dealing with, even though you might support and advocate for your client, there's going to be things about every case that as an attorney you don't agree with. There's going to be things about your client's position you don't agree with. You're going to advocate for it, but you don't agree with it. It takes an emotional toll on attorneys to constantly do that. So of all the things an attorney can work on, going to court and litigating against another attorney is the least desirable. So they want to avoid that. There's many ways you can avoid it as a client. One is to do mediation. Another is to do settlement. There may be arbitration available based on your contract. So if you are a potential client or a client and you're having a difficult time getting an attorney to actually litigate in court, there may be a good reason for it. It may be that the options other than going to court and fighting it out are more advantageous. Your attorney sees this every day. They know what's the better option because they deal with hundreds of court cases every year. You may deal with one or two in your lifetime. If you are having a difficult time finding a litigator, the best thing to do is to look at the actual court records in your county or surrounding counties and find the names of attorneys that keep showing up as appearing in court. Not filing documents, not filing notices, appearances, or even depositions. You want to find the ones who are actually appearing in court for an in-person litigation. Those attorneys are more comfortable with it. They may have more experience with it. You can even ask your attorney, do they prefer going to court or working on a conflict or dispute out of court? Almost everybody's going to tell you, as soon as you step foot in the courtroom, Your destiny is outside of your control. You are now at the mercy of the judge or the jury, or surprises that can come in court, misunderstandings that can come in court. That ship now has no control over its destination by you anymore. The court is now in control. If you are working on negotiation, mediation, settlement, arbitration, you can still control the destiny. You can take your time, you can stop, pause, think about it, come back. Once you're in court, the train is going down the tracks no matter how you feel about it. So don't necessarily be surprised or even offended if you're having resistance from your attorney to go into court and litigation, or even finding an attorney that wants to take a case if you're hell-bent on litigation. Listen to the advice of people who do this all the time. In our business as licensed private investigators, we see cases all the time that go to court, and while it does create, billable hours for our firm as asset research services, maybe background services, maybe even evidentiary documentation, it's usually not the best use of that client's funds. Usually the better use of the funds is to work towards a settlement with the client. I know everybody wants to avoid settlement because you don't want to lose. You want to make sure you prove your point or have your day in court. But that could be an expensive sense of pride. We don't want to keep you from getting the results you want, but just remember that professionals who deal with litigations on a day-to-day basis all see the downsides of throwing yourself in the ring of court-ruled litigation. Consider mediation, consider negotiation, let your attorney give you some good advice. And if you maybe want to see if maybe there's another suggestion, don't be afraid to get a second opinion. Most good attorneys will relish the fact of you getting a second opinion, especially since that second opinion is going to say, yeah, you should settle this case. And you can go back to your attorney and tell them, what your wishes and intentions are and let them work for you on your behalf. So that's a little bit of a backstory on why you're probably having difficulty finding a corporate or civil litigator to take your case or even to put it into the courthouse, because the outcomes aren't much better for the client than if you negotiated it. And that's another area where attorneys have a little bit of a cringe moment. They know that prior to going to court, there's usually a settlement offer. There's usually a mediation suggestion. There may be arbitration. And if they're rejected by the parties, when the parties go to court, the end result usually ends up being worse for both parties than what they could have accepted 6 months or 2 years before. And there's a lot of resentment in that moment. And a lot of times that resentment is taken out on the attorney. And it's not really their fault. They probably tried to keep you from going to court, but they're the ones who are the bearer of bad news and end up getting that resentment. And that's not a good place. We're all humans. We don't like to let down our clients or have our clients feel like they're in a bad spot. But a lot of times that foresight and hindsight is 2020 comes into play after the fact and puts professionals in the legal industry or adjacent to the legal industry in a place where we wish we could tell our clients what's going to happen down the road, because we've seen that movie many times before.